Good morning, everyone. Thank you all so much for joining us. I'm Grace Bergen, the Oregon Realtors 2023 president. While we're disappointed not enough folks registered for an in-person regional education summit, Oregon Realtors and Rogue Valley Association of Realtors are so excited to bring you the keynote presentation, Don't Get Burned, Cannabis, Litigations, and Data Security with national speaker Krista Curzillo, Esquire, to members from across the state. Before we get started, I want to cover a few housekeeping items. First, continuing ed is tracked based on your Zoom login, which means if you're watching with a group or with a friend, the only person registered in Zoom will receive the continuing education credit. When you join the webinar, you are asked for your name, email, and M1 number. We'll use that to process your continuing ed. If you put in a fake name or didn't enter your M1 number, we won't be able to get you your CE. If you have any questions, please send Oregon Realtors Education a message in the chat here on Zoom. Your CE certificates will be emailed from Rogue Valley Association of Realtors within a week. Trista will be taking questions throughout the presentation, so please feel free to post any questions within the chat. Today, Trista will bring her excellent sense of humor to talk about antitrust, the recent litigation that NAR is handling, as well as data security and what you need to know to protect yourself and your clients. But first, we're going to kick off this 3-hour presentation with Up in Smoke, Cannabis and Real Estate. With that, I'm so excited to announce our speaker for the session, the incredible and hilarious Trista. Trista is a graduate of Washburn University and Washburn University School of Law, where she was a member of the Washburn Law Journal. After serving as assistant legal counsel to Kansas Governor Bill Graves, Trista joined the Office of District Attorney for the 18th Judicial District of Kansas as an assistant district attorney, assigned to the Consumer Fraud Division. From 2004 to January of 2010, Krista was the Government Affairs Director and Legal Counsel of the Wichita Area Association of Realtors and the South Central Kansas MLS in Wichita, Kansas. Trista now devotes her time to offering excellent education opportunities for real estate licensees across the country. Thank you so much for being here today, Trista. Take it away.
Thank you. Good morning. As Grace said, I am an attorney, much to the embarrassment and chagrin of my parents. It makes me their least educated child and the one who can't prescribe medication. But I let you know that I'm licensed in Kansas. I'm not licensed in Oregon. So there are a few times today where we get pretty specific about Oregon law. And when we do that, we are just a close group of friends that happen to be having a conversation about the law. All right. So I get all of this like reflections in my glasses, and they're reading glasses because I'm an old lady. And so I have to decide between like the reflection or being able to read, and I'm going to go with being able to read. All right. So let me get my slide deck up here. Here we go. All right. So I want to start today by talking about cannabis in real estate and the impact that changes in cannabis laws that the states have enacted is having on real estate transactions and working with cannabis clients. Now, I can't see y'all. So the only way that I'm going to know that anyone is paying attention and I am not just talking to myself for 3 hours is if you use the chat. So if you could please use the chat to chat me questions or comments or things that you want me to dive in a little deeper, I will be more than glad to do so. And that is really the only way that we will survive this 3 hours together. So to give you a little bit of history on where we came from and how we got to where we are, we need to understand a certain amount of conflict that exists between state law and federal law. And so when we start with the history, we're going to look at kind of how that federal law has developed and then its interplay with state law. So in colonial United States, when the United States was first being formed, when it was becoming a nation, hemp was a crop that was mandated by the crown. That means all of our founding fathers were growing weed. At the time, though, we didn't have kind of that recreational use of cannabis that we see today. Instead, cannabis was used widely for medicinal purposes, and hemp was used as its fiber. So a little bit of kind of the I'm from an agricultural community. I'm from Kansas. And so the ag person in me always comes out, that farmer's daughter, when we break down how weed is grown. And so cannabis is broken into three principal species. And the reason we need to kind of understand this is because if you are working with a cannabis client, or if you have a tenant who wants to home grow cannabis, you're going to need to understand a little bit of this. And so sativa is the most common cannabis that we have grown in the United States. It is your mind high, and indica is our second most common. It's what some people will call your body high. The way my parents have, I have never consumed cannabis, but the way my parents have explained this to me is that sativa will get you high, but indica gets you stoned. And then we have ruderalis, and that's most common in Ukraine and Russia. It's very fibrous. We don't really grow that in the United States. Now, the reason we need to understand not only the species of cannabis that's grown, we also need to understand a little bit of the science in what exists in the plant. So when we talk about cannabis, we have one plant and it's grown for three different reasons. First is hemp, and that's those dense fibers that exist within the plant. They're used for your, well, it's in every product that you could possibly get at like a beauty supply store right now. It's also used in biofuel, and it's used in clothing, and it exists in a lot of different products that exist today. And then we have when cannabis is grown with low tetrahydrocannabinol, tetrahydrocannabinols. And that's when it's being grown not to get someone high. That's when it's being grown for medicinal use, or what we would look at and say CBD. That's our cannabinoids. I'm just having issues this morning. Cannabinoids. And so CBD can be anything from our psychoactive THC to non-psychoactive. And so when it's grown with high THC, that is when we would use the phrase marijuana to describe it, because legally that's the term that's used. I don't like to use the term marijuana. It has become a very racialized term throughout the course of history. And so it's a term I avoid unless the law requires us to use it. I like the term cannabis. It's the easiest, and then weed and pot because of my generational background. All right. So a little more history, and this is important, I promise. When the United States Constitution was ratified, it includes the Supremacy Clause. And the Supremacy Clause basically says if the federal government is going to regulate something, if the federal government is going to make something illegal, then a state cannot make it legal. That's our conflict, right? So if the federal government says something is illegal, then a state can't make it federally legal. A state can regulate it, which is what they're attempting to do when it comes to cannabis, but we can't say cannabis is legal if the federal government has made it illegal. So that conflict is what we're going to spend a lot of time discussing, because that conflict is what has led to realtors and real estate licensees getting in trouble because they're breaking the federal law. So a little more history. John Adams, President John Adams, grew hemp, and he also wrote several articles or entries into his diary about hemp's mind-altering capabilities. He was a huge, huge fan of cannabis, which makes not President Obama or President Clinton the first US president to publicly acknowledge their use of weed. It was John Adams. And then in 1910, there is a revolution in Mexico. And when those immigrants came into the United States, they introduced the recreational use of cannabis. So prior to 1910, if cannabis was being grown, it was primarily being grown for hemp or for medicinal purposes. And then in 1910, we see a shift into recreational use. And that's also when we see the term begin to become racialized, that term marijuana. In the 20s, Louis Armstrong plays the song Muggles. And for those of you who are J.K. Rowling or Harry Potter fans, Louis Armstrong wasn't ahead of his time talking about non-magical people. Muggles are people who like to smoke pot. So now go back and read Harry Potter again with that in mind. In the 1930s, we see a major shift in how the federal government treats cannabis, and not only its recreational use, but its medicinal use. And Harry Anslinger is named the commissioner of the Bureau of Narcotics. And he said, no one knows when he places a marijuana cigarette to his lips whether he will become a philosopher, a joyous reveler in a musical haven, a mad insensate, a calm philosopher, or a murderer. So apparently those are your only options, according to Harry Anslinger. And we see a major shift at the federal level during this time where we make cannabis illegal and cease any type of studies that are being done on the medicinal value of cannabis. Then in 1938, marijuana with an H is named as dangerous by the Federal Pure Food, Drug, and Cosmetics Act. So it's illegal since the 30s at the federal level. Then in 1970, the Controlled Substance Act is adopted. And the Controlled Substance Act kind of follows up on that Federal Pure Food, Drug, and Cosmetics Act, and it begins a scheduling process. And so under the Controlled Substance Act, any type of substance becomes part of a schedule. And Schedule 1 is your most restrictive use. So for a drug to be Schedule 1, it has to have a high potential for abuse, have no currently accepted medicinal use in treatment in the United States, and then have a lack of accepted safety for the use of the drug or that substance under medical supervision. Cannabis, marijuana, is a Schedule 1 drug. To put this into perspective, cocaine is Schedule 2. It is less restricted at the federal level. So when we look at the Controlled Substance Act, placing cannabis or marijuana as a Schedule 1 drug, that means there are very few studies that have been performed on it for medicinal purposes. The only place in the United States that it is federally legal to grow cannabis is on the campus of University of Ole Miss and a few other laboratories that have DEA contracts that are allowed to grow that. It is very, very hard to get one of those licenses or contracts to grow that, which means we have very little medicinal research. And then the medicinal research that we do have is only on one strain, as opposed to if you go into a dispensary today where there are going to be dozens of strains that are being grown and provided. So that's where we're at when it comes to the federal level. It shall be unlawful for any person knowingly or intentionally to manufacture, distribute, or dispense, or possess with the intent to manufacture, distribute, or dispense a controlled substance. So it's illegal at the federal level, meaning in all 50 states, it is illegal for you to knowingly or intentionally manufacture, distribute, dispense, or possess cannabis, marijuana. So it is also illegal under the Controlled Substance Act to conspire to do any of those things, which is why we're talking about this as a topic. Because if I am leasing property to someone and they are dispensing marijuana, which is Schedule 1, then I am a part of the conspiracy to distribute, which means we have real estate licensees getting in trouble because of the federal conflict. Now, a little bit more history. In 1971, we have our first online sale. So way before Bezos came along, way before Zappos was introduced. And you have computer science students from MIT and computer science students from Stanford. And they're using kind of this precursor to what we now know as the internet, ARPANET. And the first online sale was where they were brokering the sale of pot to one another. In the 1970s, 80s, and into the 90s, we have Nixon, Ford, Carter, and Reagan as our presidents. And within those administrations, and if anyone grew up remembering Reagan as president and Nancy Reagan and her huge Just Say No campaign, these presidents and the electorate who put them in office felt very strongly that the Controlled Substance Act should be enforced when it came to cannabis. Interestingly, some states in the 70s, including Oregon, Alaska, Maine, Colorado, California, Ohio, Minnesota, Mississippi, New York, North Carolina, and Nebraska, all took steps to decriminalize cannabis. They said, okay, it's illegal at the federal level, but we want to regulate it at the state level. And we're not going to criminally prosecute folks for possessing it or distributing it or manufacturing it at the state level. And the response from the federal government was, if you do not continue to enforce criminal acts, then we're going to pull funds in some way. And so those states' decriminalization process never took off. And it remained that way until 1996, when California attempted decriminalization again. And so in 1996, when California decriminalized medicinal cannabis, we saw a shift at that point that was followed into the early aughts, when the largest opponents to cannabis regulation began exiting the electorate, which is a really nice way of saying the people who voted to put Nixon, Ford, Carter, and Reagan in office, those folks, they're no longer voting because they're dying. And in most states, it remains illegal to vote when you're dead. So we see a major shift when it comes to our elected officials and the position that they are taking and the position that those who are electing them are taking when it comes to changes in cannabis regulation. So during the first Obama term, raids were conducted on over 270 state authorized medicinal dispensaries. So 96, California says, okay, we're going to regulate medicinal. We're not going to have it be a violation of state law to possess certain amounts of cannabis when it is being treated, when it is being used to treat a medicinal issue. And then we have states follow. And now we're up to a majority of the states. And when we look at that decriminalization at that point, so that first Obama administration, there are states that have said we're regulating cannabis, we're putting laws into place on how it can be grown, how it will be sold, how it will be handled. 270 of those state authorized dispensaries, meaning following state law, were raided and federally prosecuted. Then in 2013, so second Obama administration, the Cole Memorandum is issued. And the Cole Memorandum says, okay, we get it. States are regulating, states are decriminalizing cannabis. We at the federal government need to figure out when the Controlled Substance Act will be enforced and when the Controlled Substance Act enforcement agencies will take a step back and say, as long as you're following state law, we're going to stay out of this. And so the Cole Memorandum kind of gave some stability to the cannabis industry, and it enacted what we call the Dirty Eight. And so these are the things where the federal government will look at and say, okay, as long as this is happening, then we don't need to step in. As long as we don't have distribution to minors, as long as revenues are not supporting criminal enterprises, as long as we don't have diversions to states without decriminalization. Now, number 3 is why real estate is so tightly connected to the cannabis industry. Because if I'm going to sell cannabis in Oregon, it had to be grown in Oregon. I can't bring cannabis across state lines and enter it into interstate commerce. I can't do that. I can't have any element of interstate commerce when it comes to cannabis. And so I live in Kansas, and we are touched on all 4 sides of the state by states that have decriminalized in some way. We have not decriminalized. We don't even have hearings on bills that are introduced to decriminalize. It's not going to happen for a very long time, which is why if you hop on I-70 in Kansas and you head towards Colorado, you will see mile marker 419.9, and then you will drive a mile until you get to mile marker 421. We no longer have any mile markers that have 420 in them on I-70 heading into Colorado because they were stolen so frequently. But that's our number 3, to prevent diversions to states without decriminalization. Number 4, as long as cannabis activity is not being used as a cover for trafficking other illegal drugs or trafficking or being involved in other illegal activities, then the federal government will remain out of it. Number 5, preventing violence and the use of firearms in the production or distribution. So under the Cole Memorandum, they're basically saying if we're going to have firearms present on where cannabis is being grown or in a dispensary or in a processing plant, if we're going to have cannabis there, then we are going to enforce the Controlled Substance Act. To prevent drugged driving, to prevent the use of cannabis and growth on public land or federal property. So when we look at public land and federal property, that's going to be any of our national parks, our land that's held in trust by the Bureau of Indian Affairs, or our Bureau of Land Management land. All of those BLM, and BIA, and then our national parks, all of that public land, no use, no growth on that land. So the Cole Memorandum's in place for about 5 years, and we have different federal agencies that start reacting to the Cole Memorandum, saying, okay, this is when we will enforce the Controlled Substance Act, and this is how we are going to respond, and our regulations are going to change as a result of the cannabis industry. So these are things like banking regulations that are adopted. They do all of that based on the Cole Memorandum, and we have stability for 5 years. And then we have former Attorney General Sessions. And when Sessions takes office as Attorney General under the Trump administration, in January 4th of 2018, he repeals the Cole Memorandum. And so we don't have the Dirty 8 in play anymore. So under the Sessions Memorandum, instead, he says, in deciding which marijuana activities to prosecute under these laws with the department's finite resources, prosecutors should follow well-established principles that govern all federal prosecutions. So this changes the game because we've had stability for 5 years under the Cole Memorandum, and then we have all of our other agencies like our banking related agencies, our housing and urban development, looking at reasonable accommodations. We have all of these that have looked at the Cole Memorandum, and now we have the Sessions Memorandum that comes in, rescinds the Cole Memorandum, and instead says, do what you want to do, U.S. attorneys. So at this point, then, we have to look at how has the U.S. attorney assigned to your division handled cannabis-related lawsuits. In 2014, the Rohrabacher-Farr Amendment is adopted. So we have 2013, we've got the Cole Memorandum. 2014, the Rohrabacher-Farr Amendment is adopted. Now, Rohrabacher-Farr Amendment is an attachment to a funding bill, and it gets renewed just about every year. And under Rohrabacher-Farr, it says, okay, so we have the Cole Memorandum in place, we have the Dirty 8. So this is going to say, the Department of Justice, you cannot use federal funds to enforce the Controlled Substance Act to prevent states from implementing their own state laws that authorize the use, distribution, possession, or cultivation of medical marijuana. So if we have a medical dispensary and they are following state law, then we're going to have an end to the raids that we had in the past, because now federal funds cannot be used by the Department of Justice to enforce the Controlled Substance Act. However, if we have a recreational operation or a combined recreational medicinal operation, then we can still have federal funds used to enforce the Controlled Substance Act. We can still have those raids. We can still have those conspiracy cases brought. U.S. versus McIntosh in 2016 interprets the Rohrabacher-Blumenauer Amendment and upholds that, saying as long as you are complying with state laws and as long as it is only medicinal, then we're okay. But if we're recreational, then funds can be used. And if state laws are not being followed, then federal funds for enforcement can be used. In 2015, 1% of all electricity in the United States was consumed in the production of cannabis. In 2015, we also reached the saturation point in our market. We have more square feet of rental and lease space dedicated to dispensaries than there are to Starbucks in Los Angeles. So we start to reach kind of our glut point in 2015 in some of those states. And then in 2017, CEDO did a study and they found that more cannabis was consumed in New York City than any other city on the planet. And remember, in 2017, in the state of New York, cannabis was still federally and state and illegal at the state level. We did not have decriminalization yet at the state level. 77.44 metric tons was consumed yearly in New York City. That's the same weight as the Endeavour space shuttle. That is a lot of weed. Now, in 2018, we see this shift because under that 1970 Controlled Substance Act, where we have marijuana being Schedule 1, it included a lot of products that we would just refer to as CBD products today. And so in 2018, the Farm Bill passes. And that Farm Bill says, okay, as long as we are less than 0.3% THC, and remember, THC is that psychoactive chemical that exists in cannabis. And so as long as we have a strain that has less than 0.3% THC, it is not going to be Schedule 1. So if we are less than 0.3% THC, it's not Schedule 1. And so under the 2018 Farm Bill, we start to see the beginning of the CBD craze, where you have strains of cannabis being grown that are low THC, so they're not considered marijuana because they don't have that high THC, but instead they have a higher level of other cannabinoids. So the history stuff, it's interesting, but why are you here? And the reason you're here is those criminal conspiracy laws, they do not make any type of distinction between touching the plant, meaning you personally are involved in the manufacture, distribution of cannabis, and not touching the plant, which is where you are doing things like leasing space to a dispensary or leasing space to a cannabis grow operation, or leasing space to a tenant who is using home grow. So our cases of interest, Gonzalez versus Reich, US versus Rosenthal, both cases that have said you're violating federal law just because you're following state law does not mean that you get to introduce I followed state law to your jury to be able to demonstrate that you were following the state law, that you were following those decriminalization codes. Instead, they look at this and they're saying, by following state law, you are actually confessing to violating federal law, which is what happens in Montana, where a Montana landlord spent a year in prison because of leasing land to a medicinal marijuana operation. So a little insight into the federal government and its view on medicinal use. So remember, we have Rohrabacher-Farr that says as long as it's medicinal, Controlled Substance Act funds can't, control, as long as it's medicinal and state laws being followed, we can't use federal funds to enforce the CSA. However, if you go to purchase a gun and you fill out Form 4473, it asks on question 11E if the buyer is an unlawful user of or addicted to a controlled substance. And in the past, it just said controlled substance, and that was a yes or no. And if you answered yes, I'm addicted or I'm a user of a controlled substance, you're prohibited from owning a firearm. They have now clarified on that form that even if you have a medicinal card and you're following medicinal law, the federal government still considers you a user of an illegal substance, of a controlled substance, and so you are prohibited. Okay. So let's look at a couple case studies, and I want us to walk through this. Okay. Does this apply just to leases, or does it also apply to the sale of a property knowing the intent is to produce cannabis? And we are going to answer that. We've got a case study. All right, so let's go with this one. Okay. Got to move my little boxes around. Sally Seller contacts Rosie Realtor to list her 3,000 square foot home. The exterior of the home is in immaculate condition, and Rosie knows the property will not be on the market long. So this case study is based on a client of mine. And so I get a call from, she's the broker owner of a pretty large brokerage, and she calls me and she's like, oh my gosh, Trista, I'm going to prison. I am going to prison. And I'm like, okay, well, what has happened? Right? What is going on? She's like, my entire parking lot is full of police vehicles, and they are seizing a moving van that is parked in my parking lot, and I am terrified. And I'm like, well, what has happened? So she had an agent who went to this listing appointment, and she's going through the property, and it is beautiful. It's immaculate. It is everything you want in a property that you're going to list. And then they go into the basement, and there is a room in the basement that has a lock, like a keypad lock on the door. The client opens it and it's like, oh yeah, and then there's this room. It's a little unique. And it has 2 hydroponic grow stations of cannabis. It has a ventilation system built in. It has a drying rack system on one wall. And then on the other wall, you have everything you would need, like soil and a sink and everything that you need for this hydroponic grow, as well as the other grow that uses soil. And the client's like, yeah, but I only have the number of plants I'm allowed to have under state law. That's all I've got. So the agent's like, oh, okay, well, this could be, kind of a problem. And it kind of smells. And even with the ventilation system, it kind of makes the whole basement smell a little. It's a little skunky down here. And so the client and the agent have this discussion about what you should do with the hydroponic grow station that has these fully mature plants that are being grown. And they agree that you should just take them out. Like when we have a showing or when we have an open house, let's just move these plants out. And so they start with an open house before they have any showings. And the client's like, I really don't know what I would do with this hydroponic grow station. It's pretty big. I don't know how I would move it or where it would go while this open house is happening. And so the agent is like, I have the perfect solution. My brokerage owns 2 moving vans, and we loan those to clients all the time to use to help with their move. And so I will just drive the moving van over and we'll move the hydroponic grow station into it for the showing. We'll actually do that like the day before so we can air out that room and everything will be great. So they load up the hydroponic grow station. The agent says, I will drive this moving van now over to my brokerage's office and park it in the parking lot. Do we have an issue? What do you think? All right, this is where you hit me up in the chat. Did something go wrong? Okay. How many of you have had this situation where you have gone into a property, we can grow 4 plants, and they're growing the 4 plants. Maybe they're growing them in a locked room. Maybe they're just growing them in their basement. Maybe they're growing them in the backyard, and you are not really sure what to do. So when we have states that have home grow, we kind of have to take a look at how we handle this. So John Steinberg seems like a conspiracy. What kind of conspiracy? Like you think the client is ganging up on the agent? When we look at state law, okay, so I've got a few hands raised. I'm not sure if they have questions raising hands and want to talk or are just saying yes. Okay. So we have issues because your state law, when we go through this, we've got you can possess in private for mature plants. You can possess in public for immature plants, meaning I've bought them at the store and I'm transporting them home. it doesn't talk about what you do if you're moving 4 mature plants from one house to another, or putting them in a moving van, or driving them around. But if you have 4 mature plants and you've got them in public, it's a violation of the law. And now you have this agent who has put it in the back of a moving van, and the entire moving van is covered with the big marketing materials that has the broker's face on them. And the back of the moving van actually says, "Follow me." Glorious, just a glorious moment. So what do we do in these types of situations? And so one, we're going to avoid the unlicensed practice of law. So when you start having conversations with your clients, anything that has to do with how many plants they're growing, how they're maintaining them, what they're going to do, you're going to say, that is up to you to figure out with counsel if you need it. But we need to have a conversation, because cannabis is a highly portable, highly valuable commodity. So if you're going to be growing it inside in pots, if you're going to be growing it hydroponic grow station, if I put in the private remarks of the multiple list, there's pot being grown, you're telling the entire community that might see those remarks, we have a highly portable, highly valuable commodity. So we're not going to do that. So instead, we have to look at, how do we approach this if we are going to have home grow? And so when we look at this, one, we're going to avoid the unlicensed practice of the law. And two, we're going to work with the client to ensure that home grow laws are being followed, so that it's maintained in a private property. And we're also going to make sure that we are not allowing access to that cannabis during an open house or during a showing. So we need to have a discussion with our client about what tools the MLS will offer. So are we going to have that just in a locked room and then put in the MLS? There is a room. It's not accessible during the open house. It will not be accessible during the showing. If you need to see the room, if you're serious and your client wants to see the room, then you'll have to be accompanied in some way, or we will make that possible in this manner. But we need to make sure that we are not putting it out into the public, that we have a highly portable, highly valuable commodity. All right. Rick Realtor has an active real estate practice that involves managing residential properties for several property owners. So another one of my favorite clients. So he rents this property to, we're going to call her Mary, for several years. And Mary is sort of an ideal tenant. She's never late with her rent. On the few occasions when Rick has had to go to the property, she takes excellent care of the property. She is your ideal tenant. But Mary drops by the office one day and Rick's kind of surprised. And she's like, the lease says if my income source changes, I have to let you know. This is awesome. When you have a tenant who actually pays attention to the lease agreement, where it says, if your income source changes, you need to let me know. And she does. She comes in and she's like, I have a new job. So my income source has changed. I am now employed by ABC Cannabis Dispensary. And then she explains to Rick, ABC pays all of its employees in cash. The work that I do is entirely cash. I would like to pay you in cash as well. Now, the lease is silent about form of payment. How do we receive payment? It doesn't say no cash. It doesn't say anything other than if you bounce a check, there's a fine associated with that. So Rick has accepted cash payments from other tenants in the past. He's not had an issue with that. So he updates his file to reflect that we have a new employer for Mary. And then he tells her that the cash payments are not going to cause a problem. Now, what should Rick have done first in preparation for accepting cannabis cash? Now, how many of you, are there any property managers out there? How do you prepare if you're going to be accepting cannabis cash, or if you're going to have a change in payment like this? I was prepared today. I have my Oregon Realtors water bottle. All right. So what should Rick have done in preparation for accepting cannabis cash? What do you think? Okay, so isn't cash cash? Do they ask other tenants where their money is coming from, or do they simply accept it? Open a separate account. Does it become a money laundering issue? Denise, you are absolutely right. So if I'm working for a cannabis dispensary or cannabis industry, that money is dirty money. That's drug money under federal law. So if I'm taking that dirty money and I'm putting it into my nice, clean real estate account, and then I'm using that nice, clean real estate account money to do other things, what have I done? I've laundered that money. So when cash is king, which it absolutely is in the cannabis industry, there are a few things that we need to do. One, the landlord bank should be consulted. Depending on the structure of that landlord bank, they may have to comply with the requirements of what we call the FinCEN memorandum. So you might hear, so Randy says, nothing, not sure why Rick would ask any questions about where Mary's money comes from. And it's not that uncommon in property management to want to know source of income, except in states where source of income is a protected basis under their version of the Civil Rights Act. And so in this case, when Mary applied, you had to verify source of income to ensure that Mary could make her payments. And so in the lease, then it also says if you have a change in source of income, then you need to notify us so that we can again make sure that the funds can be paid. So what Rick did here, not that uncommon, but what Rick should have done is done a little bit more research. Okay, so Grace, that would apply whether she wrote a check for rent or paid in cash. It's where the funds originated, correct? So if my tenant, if Mary is depositing the cash from the dispensary into her bank account and then is writing a check, then it's that other bank that is doing the laundering. And so it will be that other bank's. Okay, what if Rick went to a bank and got a money order? So Rick could say, not going to accept your cash, we need a money order. And if that, when that money order comes in, then they're going to look at it's a money order. So it's not going to be the way that the bank will look at it is going to be different. So under the FinCEN memorandum, and you might hear a lot of folks will say that banks won't do business with cannabis industry clients. They won't touch that money because of the FinCEN memorandum rules from the federal government. And so the goal of FinCEN, like their stated goal, was to make it easier for banks to develop relationships with cannabis industry. It has had the exact opposite impact when we look at this, but it is not impossible for a bank to establish a banking relationship with a cannabis client. It's just expensive. And so if I'm going to be bringing in cannabis funds, then it has the possibility of raising this red flag under the FinCEN. And so we have three different kind of levels of red flag results. One is the financial institution has to file a marijuana limited filing. And so in that marijuana limited filing, they're going to look at the marijuana related business and see if any of the red flags of the Cole memorandum, even though it was rescinded by Sessions, they still are following that Dirty 8 Cole memorandum. If any of the red flags in the Cole memorandum are raised, then that financial institution is going to have to go to either a marijuana priority filing or a marijuana termination filing. But as long as we can demonstrate that our cannabis client is following state law, then it's going to be a marijuana limited filing. So if you have a bank that has cannabis clients, they're already doing that due diligence when it comes to the marijuana related business filing. So they're already prepared for that. So we do have quite a few cases that we can see across the country where businesses, dispensaries in particular, and a few related MRB related businesses, those are going to be like my testing operations, my distribution operations, so truckers, all of those types of things that are related to the industry where their banks have cut ties and they have said, we do not want to go through the MRB process. Okay, so Randy says, okay, I am a mom and pop landlord and I have 1 or 2 rentals and I do my own bookkeeping. I don't know where any of my tenants' money comes from. What then? So if you frequently, or it is not a big deal for you to accept cash and you deposit that cash, depending on the amount of cash deposited, then it's not going to raise that red flag. But if you come close to that red flag cash deposit, and if your bank asks, then that's going to be where we get into the difficult situation. The fascinating thing about this is when we look at the federal government saying this is money laundering when we take this cash, is one of the first places that developed a system for processing huge amounts of cash payments was the Internal Revenue Service. So it is illegal to operate any cannabis business in the United States, right? As long as we're above 0.3% THC, illegal. So all of my dispensaries, my manufacturing, my grow operations, my testing sites, all of those businesses illegal at the federal level. They still have to file taxes on their illegal income, and different IRS offices have had to change the way that they receive tax payments because they're getting their taxes paid in cash. So yeah, your federal government is also money laundering. All right. So when we cannabisize that lease, if we're going to lease to a cannabis business, or if we have a cannabis employee paying in cash, we have to have a different system in place to process those cash payments. So if we already have a system in place where we take cash payments, there's not going to be a change. But if we are going to be taking a large cash payment, then like over several $1,000s, then we're going to need to have that new system in place. Does a money order protect the landlord in the state of Oregon if the lease states no operation of a home business in the property? For example, if the tenant lies on the application. So it would depend on the business. Like if someone is growing just their 4 plants, it's not a business. But if it's a business, then they're not going to fall within that licensure requirements of the state, so you're going to have a problem. All right. The lease has to address any particular requirements of cash process that are different from a traditional lease. So Mary comes back a couple months later and she says, okay, my mother has been diagnosed with cancer and I want her to live with me while she is receiving treatment. And the lease says if I move a new tenant in, I have to have them, on the lease because they're living here as long as they're over the age of 18. So I need to have my mother added to the lease. I want to see if that's going to be a problem. And then my mother is also using medicinal cannabis, and her preferred method of ingestion is smoking this. So you have in the lease a no smoking policy, that there's no smoking in the unit. Can you change that no smoking rule so that my mom can consume her medicinal cannabis in the way that she wants to? And so Rick contacts the property owner and says she wants to add her mom to the lease. I know that's usual, but you do have this no smoking clause. Are you okay if we change the no smoking clause to allow for the consumption of cannabis via cigarette by her mom? So what should Rick have checked before making the change? Because the property owner asks Rick, well, is there a problem with that? And Rick says that he doesn't know of any. So what should Rick have done? What should his action have been? What do you think? Okay, check the laws, talk to a lawyer. What does the law say? Okay, check to see if Mary's mom has the proper card. Okay. Now, when it comes to consumption under Oregon law, your property owner can say no home grow, no consumption, like that's within the purview. However, the interesting thing here is if we are dealing with if we're going to have cannabis being consumed, or if we're going to have a cannabis dispensary or a grow operation or a test operation, anything that is going to touch that product, we have to look at the underlying mortgage for the property. The majority of mortgages, almost all of them, have language saying that if we have illegal activity, then we can have a consequence. So most underlying mortgages forbid illegal activity. So if I have an illegal activity happening in my property, then most leases will have a consequence. The most popular or the most common consequence for having an illegal is going to be to having illegal activity is going to have lease acceleration. And so the most common way that we hear this is, I'm going to call your loan. And so this would be where the bank says we have an illegal activity happening. So we hold the mortgage for your commercial property, and now you have a dispensary. And sure, the dispensary is following state law, but they're clearly in violation of the federal law, which says no distribution of anything over 0.3% THC, and that's what the dispensary is doing. So we have illegal activity because remember that mortgage is looking at federal law. And so at that point, then they can accelerate that loan. So we need to make sure that if we're going to definitely have any commercial touching of cannabis, that we're checking for that underlying mortgage. And then we also want to look at if we have a tenant, what's going to be the impact. So when we cannabisize the lease, if you're like, okay, I will allow for cannabis to be consumed on the property, they need to clarify if there are certain forms that are not going to be allowed, because cannabis can be ingested in numerous ways. We have smoking, we have edibles, we have vaping, we have dabbing. Some of those cause more damage to property than others. Dabbing causes pretty significant damage to property. So when we look at that, that is something we want to take into consideration. Are we all familiar with dabbing? This is where I'm used to looking at people's faces. Okay. Oh, I've got no's. Okay. So dabbing isn't dabbing because that's over. That's done. Dabbing would be, so Grace, who introduced me, you kind of look like maybe you like Yankee Candles a little. Are you a Yankee Candle lady? So when we think about Yankee candles or any type of candles, frequently you'll see wax melts. And so you'll have like a warming tray. And there are a few different ways that the tray gets warm. Some you plug into the wall and the tray gets warm and it melts your wax. And then you have yummy smells that are going across wherever your wax is being melted. Or you might have one where you actually light a candle. And then that candle heats up that wax melt that's on top, and then you have yummy smells that are distributed. Dabbing is very similar, but instead of having yummy wax melts, you have a cannabis resin. And so the goal, it's a little bit more complicated, but you heat the resin in a similar to a candle warming situation, and then the resin and cannabis is distributed through the air, as opposed to like vaping or smoking where you're inhaling. It is just in the air and then you inhale. Now, one of the problems that some property owners have with dabbing is it leaves, or has a tendency, depending on your resin quality, it leaves like a sticky residue on everything that it touches. If you have multi-units, it can also get in your air ducts, and it will be distributed where you don't have a lot of control. So I have quite a few residential clients who are either doing Airbnbs or they are doing long-term rentals. And they will say, I'm going to put language in here. I know I'm in a state where cannabis is super popular, and people might even come here for vacations where they just want to sit around and smoke, or they want to sit around and consume. I want to have language in here that limits the consumption. And I'm going to say edibles are fine, vaping is fine, dabbing is not. And so that's language that we put in. So you kind of want to pay attention to that. Then when we cannabisize the lease, boilerplate contracts, boilerplate leases usually have language like all laws will be followed, or I agree not to violate any laws. But if you're going to allow for the consumption of cannabis, whether it's home grow or consumption, you'll want to change that boilerplate language because they will be violating laws because they're violating the federal law. So you want to look more at language like the tenant will comply with all applicable state and local laws, including but not limited to the state marijuana licensing and program rules. So they will be, if they're going to have possession, they're going to stay within that allowable ounce. They're not going to go over that and then if they're going to be growing, they're not going to go over that 4 mature plant rule. Now, the interesting thing about Mary and her mom, so her mom is using medicinal cannabis. So the question always then becomes, under the Fair Housing Act, if someone has a disability, they can ask for a rule to be changed. Remember, reasonable accommodation, as long as the change will in some way alleviate one or more symptoms of their disability or allow them the equal use of the property. Okay, so can someone make a request saying, you say no violating federal law, you say no smoking, I'm going to make a reasonable accommodation request and say, I'm disabled, I need to have the rule changed for me so that I can consume or that I can grow. What do you think? Is growing pot a reasonable accommodation? This is a weird one. And the federal government issued the Kanofsky Memorandum. And the Kanofsky Memorandum looks at this in 2 different ways. They look at is allowing for home grow or is allowing for consumption of cannabis over 0.3% THC where it's a violation of federal law, is that a reasonable accommodation? And they've said no. You don't have to make a reasonable accommodation to allow someone to violate the federal law. And then the Kanofsky Memorandum goes even a step further, and they look at if we are Section 8 or if we are a federal program and you know that your client has a medical card, or if you know that your client consumes, that makes them a drug user. The same as that form that you fill out when you want to own a gun. So the federal government treats it the same, gun ownership and Section 8 or any federal programming. And so they say, okay, if you're going to use HUD money, if you're in any federally subsidized housing, you cannot rent or lease to someone if they are in one of those programs if you know that they have or use cannabis, even if it's for medicinal. Now, what's interesting is we have a case that comes out of Forest City Residential Management versus Beasley upheld the Kanofsky Memorandum, and they say you are absolutely right. But then we have a case making its way through the Pennsylvania courts. And in that case, the court said no, that criminal law is purview of state. And so if you are going to have a reasonable accommodation request, or if you are going to have a Section 8 request come in, and you know the person is using medicinal cannabis, then you do grant that reasonable accommodation, or you do not evict, you do allow them to participate in the federal program. So that's making its way through Pennsylvania. I'm excited to kind of see what happens to that, but it is stuck in the courts right now. All right, so back to Rick and Mary. So Mary's paying her rent in cash. Mary's mom is living with her. Mom is smoking cannabis, and Rick has said it's fine. So has property owner has said that that's fine. But then Rick gets a call one night and he is informed by the local fire department that the property rented by Mary is in flames. It's on fire. He drives to the property. He's met by law enforcement. They inform him that the property is a complete loss and the fire was caused by faulty wiring in a grow light that was being used as part of a system to grow cannabis. Mary is at the property and explains that she and her mother had been growing the cannabis used by her mother to alleviate the symptoms of her illness. So here are our questions. Will the property owner have an issue with receiving payment from his insurance provider? So he has a fire that was started by a grow light that his tenant had. Is he going to be able to file an insurance claim and receive payment for the loss of the property? And then that second that we've already discussed is, can my landlord or my property owner refuse to allow the cannabis to be grown? All right, so what do you think? Are we going to have an insurance issue getting paid for the damage to the property? So was insurance notified of this new use within the property prior to the fire? Okay. It's not a notification issue, it's a policy issue. And so this case it's based on a case out of the state of Missouri. And what happened in the actual case is you had a tenant who was out on the back deck and they are smoking a marijuana cigarette. They have a medicinal card. They are using it medicinally, but they get distracted while smoking and they flick their lit marijuana cigarette. It falls onto the deck and then it falls in between the boards of the deck flooring and it goes underneath the deck, which is where this tenant was storing his lawnmower, extra gasoline, and bags of dry leaves. So what happens if you take a cigarette that is lit and you toss it onto a bag of dry leaves? You have a fire. Now, this is so crazy to me. So if I had just a bucket of gasoline and I flicked a cigarette into the bucket of gasoline, it's actually not going to explode. It's actually not going to start a fire. You don't have enough space. The cigarette's not large enough to actually start a fire. Just a little side note, science, which is what someone testified to in this case. But if it falls on the bag of dry leaves and then the dry leaves catch on fire, then it will become a major issue then when it hits the gasoline that's left, the gasoline containers, and then the lawnmower that also has a full tank of gas. So in Missouri, in the case, the entire property is completely lost, and then our insurance adjuster comes. And so the insurance adjuster determines cause of loss, which is why did we have the loss? And so if the insurance adjuster comes and says the property was a complete loss because of a fire, then insurance will cover that loss. But if they come and they say, okay, the loss was caused by a fire started by a cannabis ember, and cannabis consumption, that cannabis ember, that's against federal law, then insurance will not pay, because in your insurance contract, there's language that says if the cause of the fire is illegal activity, if the cause of the loss is illegal activity, then it's not going to cover that. Okay. So Randy says, in this case, though the grow light was not part of house electrical, this will be a problem with the insurance company. The problem the insurance company is having in Mary's case is that the grow light was for cannabis. And since it was part of a grow operation, it's not going to be covered because that's an illegal operation. And the Missouri case, everyone always wants to know, how did the insurance adjuster determine that the fire was started by a cannabis ember and not a just cigarette, or not just some other, dropped ember from a barbecue or something like that? So how does the insurance adjuster find that out? What do you think? She interviews the tenant, and the tenant told her, you're absolutely right, Crystal. The tenant said, I was out back, I was smoking my medicinal cannabis, I flicked it, and yeah, now there's a fire and it's gone. So insurance, when we look at this, so we have what is called the Claim Act, clarifying law around the insurance of marijuana. And it has passed the House several times, the United States House of Representatives. It gets bogged down in the Senate because they're very busy with other things, because they're very important people. But what Claim would do is it prohibits federal agencies from penalizing or discouraging insurers from underwriting or handling claims for a cannabis-related business. So right now, you have insurance providers who are very nervous about writing an insurance policy on any commercial cannabis business. They shy away from that. You also have a lot of insurance providers who are very nervous about adding language to a residential insurance coverage or a commercial coverage for a landlord property manager situation if cannabis is going to be grown or if cannabis is going to be consumed. Because most of your insurance, remember, it's got that illegal activity clause, the same as your underlying mortgage. So the Claim Act's goal was to make it easier for folks to get insurance when they're in the cannabis industry, but it has not become federal law because the Senate's busy. It would also forbid terminating or canceling the licenses of an insurer solely because the insurer engaged in the business of insurance in connection with a cannabis-related business. So the protections of the Claim Act don't exist. And because the protections of that Claim Act don't exist, we still have insurance companies nervous about writing that policy. But if you are going to lease and you know cannabis is going to be grown or consumed, or it's a commercial cannabis business, you want to contact your insurance provider and say, we need to add a clause. And so the clause will then say that as long as state laws were being followed, as long as we're following the state law that regulates our cannabis industry, then insurance will cover loss, even if it was caused by that cannabis industry. So when we cannabisize the lease, if a landlord or property owner allows for home grow, the lease should address what system is allowed and what type of insurance must be carried. So if you're going to have that 4 plants and you're going to allow them to be grown, you can say it's got to be grown outside, or it's got to be grown hydroponic, or if you're going to have a certain light system in place, you can regulate how that's going to be done. And you can also say you need to contact your renter's insurance company and make sure that we are having coverage from a renter's perspective as well. And if home grow is allowed, then I want you to include a trigger clause. And so a trigger clause is language in the lease that says, if this happens, that's cause to terminate the lease. I don't have to give you the 30 or 60 or 90 days notice. I don't have to go through that process. I can immediately trigger the lease termination. And that would be if someone is growing and you're having nuisance complaints, or if they're smoking and you're having nuisance complaints, anything that's related to allowing cannabis, and you're getting a lot of complaints, you're going to have that as your trigger clause. If it's a dispensary, if it's a grow operation, and you're having a significant amount of complaints, or you're going to have a change in whether that's an allowed activity in that community, then trigger, and you're going to be able to immediately terminate the lease. Okay, so here we go again, another case study. Ronald Realtor has been working with MJ Bud for over a year trying to find the perfect location for his cannabis dispensary. So Bud's outgrown his current space, and so he just needs more space, and he doesn't want to lease. He wants to own the space. He wants to buy the space. So he does say, if I have to lease it, I will, but I really would like to own it. So our realtor finds him an ideal location, but agrees that it is workable. And so Ronald contacts Ollie, who's the owner of the property, and he says, I have a potential buyer, or I have someone that might lease your property. Ollie finds out that it is Bud. And he says, I'm not selling to a cannabis business, but I will lease to a cannabis business. I want him to pay a low monthly rate, and then I want a percentage of the dispensary profits. Is there a downside to that type of agreement? What do you think? It's not that uncommon of an arrangement in some areas where you will have, we're going to have flat rate, and then percentage of profits is going to be kind of what makes up the rental situation for me. But do we have a problem with that if it's a cannabis business instead of a non-cannabis business? What do you think? Okay. So we have a knowledgeable landlord. They're now involved. Okay. Crystal's like concerns about connectivity to illegal activity, money laundering, and etc. If you're receiving a percentage of profits, you become a partner in the business, right? And if we look at the licensing that's required to become a partner in the business, then that's a process that they would have to go through. And so you have to say, do I want to be a partner in the business? And then your business is going to have to say, do I want that individual as a partner? Am I comfortable with that? And then you also want to look at any licenses you hold, like your license to sell real estate, my license to practice law. Any of those licenses, is there language that would say my license could be terminated if I'm involved in an illegal activity? And so we want to pay close attention to that language as well. Bud refuses the proposed lease arrangement, and eventually Ollie agrees to sell the property. Upon closing, Ronald expects to receive the commission rate outlined in his agency agreement. All right, our buyer's agent wants to get paid. Ollie, our seller, not represented by an agent. Bud responds to Ronald's request for payment by claiming the agreement was for an illegal purpose and is therefore unenforceable. The agreement clearly stated Ronald was to find a location suitable for a cannabis dispensary, a use which is illegal under federal law. So does Ronald get paid? What do you think? If you have a client approach you and they say, I outgrown my dispensary, I need a larger dispensary, and you know I'm helping you find a dispensary, are you getting paid at the end of the day for working with that buyer? What do you think? So we take a look at contract enforceability. Before this class, I would have said yes. After this class, you're going to say no. So when I took the bar exam a million years ago, our very first question on the written portion of the bar, it was this: you had a family whose patriarch died, and they left their land to 5 siblings, and the siblings all attempt to like oust one of the other siblings, and then they sell the property to a pot farm. And you go through this entire like thing, and then they're like, will the realtor that handled the sale get paid? I mean, that was the end question. And it's a trick question. Like the whole point of that question was it wanted to lead the future attorney astray and doing a breakdown of ownership and on who was responsible to make sure which agent got paid and what language is in the contract. It's all baloney. It's basic contract law. And that is, you cannot have an enforceable contract that is for an illegal purpose. And if you are helping someone do something illegal, like open a dispensary because it's illegal under federal law, then you've got an issue. But there are 2 cases that I think are fascinating. And so we have Mann versus Gullikson, 2016. And remember, 2016 means we're after the Cole Memorandum. And so in Mann versus Gullikson, in this case, Mann versus Gullikson, the court says the federal government's wavering policy on medical marijuana isn't going to really impact our decision here. And so plaintiff Mann sells his marijuana business to Gullikson. Gullikson is going to pay $400,000 in 3 installments. He doesn't pay. So Mann sues, saying breach of contract. And that makes sense. I had a contract. You're supposed to pay me. You haven't. Gullikson then moves for summary judgment. And he says the contract is void. It relates to medical marijuana, which is a prohibited substance under federal law, under that Controlled Substance Act. So it's illegal. It was for an illegal purpose. The court, however, says even where contracts concern illegal objects, where it is possible for a court to enforce a contract in a way that does not require illegal conduct, the court is not barred from according such relief. So post Cole Memorandum, they're like, we got to figure out a way to deal with this issue. And so the court looks at it and they say touching the plant's illegal, but possession, cultivation, distribution, those are in violation of the Controlled Substance Act. But just paying what you owe, that doesn't require touching the plant. So in this case, the court brings in this whole touching the plant, not touching the plant. which we have since seen courts say does not apply. And so then we look at a case that is pre-Cole Memorandum. And the pre-Cole Memorandum case takes the opposite approach of Mann versus Gullikson and refused to enforce a contract where funds were loaned to a cannabis business. So we have the Cole Memorandum and we have a post-Cole case, but then we have the Cole Memorandum repealed. So the question is, do we go back to pre-Cole, or are our post-Cole cases still going to be upheld? I don't think we need to get into the entire analysis there. It is much easier if you just include in your contract that the parties will waive defenses to enforcement. So if I say I waive that defense, then I cannot come back later and say I have a defense to the contract. It was for an illegal purpose, because I've waived that. I've said I will not in federal court, I will not in state court, I will not claim it was not enforceable because it was for an illegal purpose. I've waived that defense. So when I waive the defense, it means the contract will remain enforceable. You also want to include arbitration as a method to resolve disputes. All right, so are there questions about cannabis and our cannabis cases before we move on? So we're together for 180 minutes, and I think I'm right, Grace. And Erica, if I talk for 150, they get their continuing education credit. So if we take a short break now and come back at 10:30, then I can spring them a little early, right? Yeah, right, because we do 150 minutes. All right. Oh, so I had a question. I can't get past locking a door, and the first case study isn't concealment. So can I lock the door where the cannabis is, or am I concealing something? So if I make that disclosure and I say there is a room and it is going to be locked, and then you want to see it later, and I will make arrangements for you to see it, then we're cool in the game. You know, I'm keeping that locked because I've explained the situation. And it's not that uncommon in some parts of the country to have rooms that are always going to be locked. Missouri's cannabis law says the room always has to be locked, and it has a certain system in place for what the lock even looks like and who is allowed past the lock. And under that one, the potential buyer has to be accompanied by the seller or the agent of the seller to get past the lock. And so I always laugh because I'm like, if I'm looking at remarks and it's like, there's a room in the basement and it's locked, we'll let you in if you really want to see it. Being a Kansas girl, my mind immediately goes to either that's where they're storing all their guns, or that's like their 50 Shades of Grey room. Kind of creepy, kind of weird. All right, so let's take our 15-minute break. We will come back at a little after 10:30 and get through with the rest of the day. All right, I will see you soon. All right, are we ready to come back? All right. I have this weird thing about webinars because I don't see anyone. So my fear is that like I'm going to come back and start talking and nobody else is there and it's just me entertaining myself for like an hour and a half. All right. So let's move on to, yes, Caitlin. Do you have a question or letting me know that I'm not alone? All right. Thank you, Caitlin. The joys and the things that you don't expect from Zoom. Like pre-Zoom, I never realized that I probably should get braces. Like I really think so. But now that I spend a couple hours a day just looking at myself, I'm starting to really become insecure. All right. Can I say that? So I want to talk about the antitrust litigation that the National Association of Realtors is involved in, and several of our large local boards as well. But before we get into that, I want us to have a little bit of background information so that we can kind of apply what we know and understand about antitrust to the litigation to kind of have that in mind. Because if we just look at the litigation without kind of that background, it lacks something. And I know for so many people, our antitrust knowledge was limited to a few cases from when you got your license, which might have been a month ago, it might have been 30 years ago. And so I feel like we just need a little bit of a review. So when we look at the regulators of antitrust behavior in real estate, we have the Sherman Act, 1890 is when it was adopted, the Clayton Act in 1914, the Federal Trade Commission Act also adopted in 1914, and then this year, well, about a year ago, President Biden issued Executive Order 14036, which is the executive order on promoting competition in the American economy. So we have kind of, these are not new laws, they're very old laws. And so we have new behavior and new tools that we use. And then we have these kind of older laws that have to apply. So when we take a look at the Sherman Antitrust Act, because that's the basis of most of the litigation we're involved in today, 15 USC 1, it's every contract combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. Now, I read that and I don't follow. I don't understand. What on earth does that have to do with real estate? How do we tie that into any of the behaviors that we're talking about today? So we're going to deep dive. Why are we really talking about it? Criminal penalties. For an individual, it can be a fine of not more than $1 million and imprisonment of up to 10 years. For corporations, a fine of not more than $100 million. And that's if the Department of Justice is taking action. The volume of commerce is going to drive the sentence for both. So the more commerce involved, the higher the fine can be. Restitution being paid to identified victims. So if we're looking at a class action lawsuit, like the ones we're about to discuss, we're looking at identified victims being paid. And then we have civil lawsuits. So that's where we don't have Department of Justice action, but instead we have a civil lawsuit. And civil lawsuits can claim up to 3 times the damages. So if we can demonstrate damages in a class action, then we can look at potential for treble, 3 times those damages. So the reason we look at these is because they can really impact our industry. So what does a violation look like? And most of us probably remember US versus Foley. It was the seminal case. It's from the 70s. Most of your pre-licensure classes cover this. And it's where you had like the largest broker in Maryland. And he has a holiday party. and he calls in all of his competitors, and he stands up during the dinner and he says, I don't care what the rest of you do, I am raising my commission rates to 10%. And then he sat down. And then other people that were at the party start having a conversation, and then they also raise their commission rates. And I always say 10% because it's one of those things that it's easy for me to do the math for 10%, and I struggle with the math, but he listed the actual percent number that he was going to raise his commission rate to, and other parties that were at that dinner fell in line. So when we look at that conversation where a competitor stood up in a room of other competitors and said, I'm raising my rates, I don't care what the rest of you do, we have a few things that we have to look at, which is the elements of a violation. So did his comment rise to a level that it's a violation of the law? And then what about the competitors that were in the room? So the charged conspiracy was knowingly formed and was in existence at or about the time alleged. The defendant knowingly joined the charged conspiracy or intended to agree. The charged conspiracy either substantially affected interstate or foreign commerce or occurred within the flow of commerce. And then we have a 5-year statute of limitations. So when we look at the charge in US versus Foley, it was price fixing. And so price fixing is a per se violation, as is bid rigging and market allocation. Boycott also used to be a per se violation. It is not always anymore. And if we have a per se violation, then the Department of Justice doesn't have to prove that the agreement was successful. So if I have a group of competitors and we all sit in a room and we're like, it's pretty easy to figure 10%. Let's go to that. Yeah, let's do that. That sounds like a plan. But none of us actually raise our commission rates. The Department of Justice doesn't have to prove that our agreement was successful. They don't have to prove that we actually followed through. And then loss or harm as a result of the agreement, they don't have to demonstrate that anyone was harmed, and then that the conduct was unreasonable or lacked economic jurisdiction. So price fixing is when we have an agreement to charge the same price or to raise prices together. We're going to add fees. We're going to have certain surcharges that are going to be added. We're no longer going to have discounts, or we're all going to offer the same amount of a discount. We're going to have minimum prices, and then, or we're going to have a standard pricing formula, or we're going to coordinate not to compete. We're going to agree that there are going to be certain commercial terms that we're just going to keep in mind. That's price fixing. So when we look at price fixing and we look at the behavior of the people in the room, we don't necessarily know that everyone at the US versus at the Foley dinner table said, hey, I think that's a good idea, we should do that. But we do know that some of them left the room and raised their commission rates as a result. So we do know action was taken. So when we look at the conspiracy charge, that is, the conspiracy is an agreement, an understanding or meeting of the minds between at least two competitors for the purpose of restraining trade. The agreement is what constitutes the offense. Overt acts in furtherance of the conspiracy are not needed. So if I just say, yeah, that sounds like a good idea, count me in, I'm part of the conspiracy. If I stay silent and I don't say anything, but then I change my behavior, then my behavior demonstrates the conspiracy, that we had an agreement and I followed through with it. So knowingly joined, mere knowledge of the conspiracy without participation does not make the defendant a party to the conspiracy. So if I stay silent, but then I also don't do anything, then potentially I'm going to have the government's going to fall in its ability to show that I was part of the conspiracy. However, the defendant will need to demonstrate that any actions taken weren't made based on that knowledge. So when we talk about the knowingly joined and silence can potentially weigh in, that's where I always advise clients, you need to be prepared to say, if I'm in a situation where somebody has said, hey, I think it would be a great idea if we just quit doing this, or we started doing this as a group, or we all charged the same amount, you've got to extricate yourself. You've got to get out of that situation as quickly as possible. And so you want to speak loudly and say, this is a violation of the law, not comfortable with this. And then the charged conspiracy either substantially affected interstate or foreign commerce or occurred within the flow of commerce. And this is one where I've had agents argue with me and they say, I sell real estate. Real estate doesn't move. That's intrastate commerce. But when we look at the flow of interstate commerce, we look at your business as a whole. And so if you're advertising across state lines, if you're working with relocation services, if you're working with a seller who is moving out of state, or a buyer who is moving in state, or if you're using funds that are coming from an out of state institution, or is it a federal program? All of those are interstate commerce. So it does your business enter the flow of interstate commerce? And if I have a website, I'm advertising across state lines, and the majority of you out there have websites or you have a Facebook page that you advertise your business on. All of those are going to qualify. So this is where we talk about what I call your Miss America, which is I found myself in a situation and I need to extricate myself. How do I do that without offending the other person? So one of the first antitrust cases that I ever taught, we ran through US versus Foley, and I had people act out, like, what would you do? So Foley stands up and he says, I'm going to raise my commission rates to 10%. I don't care what the rest of you do. And then we discussed, does that cleanse his statement? Can I say anything I want? Antitrust. But I call it the Seinfeld exemption. I can say anything I want, no matter how offensive, as long as I follow it up with, not that there's anything wrong with that. Can I invite people to be involved in a conspiracy, but then claim it wasn't a true invitation because I said, I don't care what you do? And no, you can't cleanse that statement. You can't cleanse an invitation to conspire. And if you're at an event, or if you're involved in like a Facebook group where you have a discussion that is veering into antitrust world, your Miss America is going to be, how do I get out of this? And so in that class, the first one I ever taught, there was a woman in there and she's like, I have been in antitrust situations, and Trista, this is what I do. I look at that person and I say, let's see, who's in my class right now? Marsha, what you're proposing is a violation of the federal law. You belong in prison, and I look forward to working with your clients while you're there. I was like, snap. I mean, that's aggressive. I was like, that's a lot to take in. And then I started thinking, but what happens then the next day when I have to call the person that I just said you belong in prison, and I have to say, hey, I'm sending you an offer. It might have been a while since you've done a VA loan, or, you know, this one's going to require some finesse. That's an awkward situation. So your Miss America is, how do I extricate myself, but I continue to have a working relationship with that person? So I'm not comfortable continuing this conversation. I'm concerned it may be an antitrust violation. You say it and then you leave. I am leaving before this discussion goes further. And then you leave. I have sensitive skin and the prison uses cheap soap. I will not be participating in any conspiracy to restrain trade. And then you leave. And when we say, I am not participating, and then you don't participate, then you have a complete defense that you were not involved in the conspiracy. So when we look at our online behaviors, it's things like this, where we have this article and the comments to the article say things like, we should boycott Zillow, we should boycott this company. And then over here, our association needs to do something, calling the association to action in involving not doing business with a certain agency or certain brokerage. And Chip Allsweed, who was the Beverly Hills Association of Realtors chief executive at the time, said neither the association nor the MLS can decide to not feed to any one company. For an organization to do so would violate US antitrust laws. And then an agent who was commenting on this article saying we need to boycott says, I don't agree. Well, he's actually giving you word for word the Federal Trade Commission's response as to what a boycott is and saying we can't participate in a boycott. Now, a boycott is a per se violation if it's done with the intent to harm the boycotted party. So if I'm part of a Facebook group and you're part of this Facebook group and I'm having beef with a builder and I say, you know what we should do If everybody just agreed that we are not going to show that builder's houses anymore, we would drive them out of business. And then you're like, yeah, Trista, that's a great idea. Count me in. My intent is to harm that builder, that boycotted party. My intent is to gather competitors and say, we're not going to do business with that party anymore. And by doing that, my intention is to harm them. And that's going to be a boycott. That's against the Federal Trade Commission Act, as well as my Sherman antitrust. So if I'm online, if I'm looking at that article, how do I flip a table? How do I steal the booze? How do I get out in a way that people are going to remember if it's online? So we're going to either comment on the inappropriateness of the discussion, voice your unwillingness to participate. So if I'm in a Facebook group, I'm going to say, hey, I don't appreciate this conversation. And I keep bringing up the Facebook group because there are two different associations, neither of which are in Oregon, that are really struggling with a Facebook group right now. And it's a group of agents and brokers, and they actually created this group for no reason other than to create a boycott against a builder that they have beef with. Leave the group, unfriend it, report that the contents are a violation of the terms of use, because all of our social media platforms say that if we're creating a group for no purpose other than to organize a boycott or to violate law, then that is a violation of the terms of use. And then also document my behavior didn't change because I knew that some of my peers were involved in this. I didn't change my behavior because of what I saw or what I read. So our litigation roundup. So keeping in mind, we've got our big four, and then we've got this litigation roundup that alleges we have a violation of antitrust laws. So we're going to start with the big one, which is Merle versus NAR. And so when we look at this one, the claimant, Merle, is saying that in a truly competitive market, the buyer would pay the buyer's agent. Now, some of you immediately, Realtor Brain On, are saying the buyer does pay the buyer's agent because the buyer pays the money to the seller to purchase the property in a traditional commission structure, I guess I should say. So a traditional commission structure would be, I have the proceeds of the sale. And so the proceeds of the sale go from my buyer, who presents the proceeds, to my seller, who receives them in exchange for the property. And then from the proceeds of the sale, a certain amount is distributed to the agent representing the buyer and the agent representing the seller. So traditional commission structure. So what this case is saying is that that's not really how it works, that the buyer isn't actually paying the buyer's agent because it's proceeds of funds, it's really coming from the seller. And unfortunately, this has been supported by some agents who have said, buyer's agents are free. And I've seen advertisements where buyer's agents have said buyer's agents are free. Well, the problem then is, do we have a buyer's agent who's truly representing the buyer if they're being paid by the seller? And then we look at that offer of compensation. Now, remember, in your multiple list agreement, we have an offer of cooperation and compensation. The Code of Ethics says you will cooperate. The multiple list says you will compensate. And so because it's a blanket offer of compensation made by the seller, then the seller is limiting the buyer and the buyer's agent's ability to negotiate the price. So the price is not something that my buyer and my buyer's agent can negotiate. Instead, it's being set by the seller. So their claim also is that this inflates sales prices unfairly in a market where the role of a buyer's agent is diminished due to buyers using internet tools to gather information previously provided by a buyer's agent. Ooh. So then this claim is that in today's market, with all of the tools that exist, the buyer's agent isn't actually providing services equal to what they are being paid, because the buyer is doing so much work themselves. Because it takes, it is a lot of time to watch like 40 hours of HGTV a week to become knowledgeable, if you're going there. The commission remained the same regardless of the buyer's broker's experience or his buyer broker's experience or the value of his or her services. So when we look at the Murrell claim, it kind of attacks the entire concept of buyer's agency under the way that it operates today, and then the manner in which that blanket offer of compensation is made, because it takes away the ability of my buyer and my buyer's agent to negotiate. And then it also looks at this and it's saying, now, if I was a brand new buyer's agent and this buyer wants to hire me, they can say, you're brand new, I should pay you less. As opposed to, I have a really complicated transaction, and so I need an agent who brings so much more to the table. But both of those agents, brand new, more experienced, complicated transaction, not complicated transaction, same compensation offer, they say that's not fair. That's a violation of antitrust. And 10 is October of 2020. It survived the National Association's motion to dismiss. So the court said, we have enough in our claims that we do have the potential that we do have a violation of the Antitrust Act. And then in February of last year, the plaintiffs filed for class certification. And so class certification means we're becoming a class action. And so with a class action, we're going to have quite a few more members come to the party that are going to join that claim. And so that's going to be folks who have purchased properties or have sold properties, and they're going to say that that buyer's agency structure harmed them in some way. They paid, if it was a seller, they're going to say, I paid that buyer's agent. If it's a buyer, they're going to say, I wasn't able to negotiate. And so that's where we're at on Murrell. Sitzer versus the National Association of Realtors claims that NAR affiliated multiple lists. So any of the multiple lists that operate in the country that are affiliated with NAR and are following those rules that NAR promulgates control much of the residential brokerage market, and the rules create a skewed compensation structure. So they're looking again at that blanket offer of compensation and cooperation. In April of last year, class certification was granted, and June of last year, class action attorneys began notifying members of the class. I apparently am a member of this class. I had no idea, but I get the ads on Facebook. I get the ads, they show up on the side if I'm using Google, and I've gotten at least 2 emails from attorneys representing this class because I have both sold and purchased a house within the last few years. So I'm considered part of this, so I get to follow. It's fascinating. I'm not going to join, but definitely I'm going to follow kind of as we go, because this is a major danger to what could happen. And then we have PLS.com versus the National Association of Realtors. Now, PLS.com is sort of a multiple list. And so in this case, PLS.com claims that the clear cooperation policy of NAR discourages the use of competitor listing network, deprives consumer of choice, and inhibits innovation by services responding to consumer demand. So when we look at what PLS.com is saying, they're saying now, to be a member of the National Association of Realtors and follow their rules, to be a member of an MLS that's affiliated with the National Association, you have to follow the clear cooperation policy. And that clear cooperation policy is within a certain amount of time, my listing will go into the multiple list. I've got a contract, it's in the multiple list. It's not going to sit out there for an extended period of time and not go in the MLS. Now, what PLS.com says is by forcing the hand of that agent to put it into the MLS, it limits their ability to say, I don't want my listing to go into the MLS. So I might have a client who says, I don't want it in the MLS because the MLS syndicates, and I don't want it to show up on Realtor.com, and I don't want it to be on Zillow, and I don't want it to be on Trulia. I don't want it to be out in the world. I want it to be very private on who's going to see my listing. And so in that case, that's where we have alternative multiple lists, more like PLS.com, where they're going to say, you can put it in here for now if your client wants privacy, or you can put it in here if it's not ready for traditional marketing yet. So it's mid-flip. Well, it's not ready to go into the multiple list where I'm going to have people coming through and I'm going to have, showings, and I'm going to have to take care of all of those things because we're mid-flip. But I am going to put it in this alternative multiple list, that is where investors go, and they're just looking for investment properties. They're not looking for properties that they would then later live in. And so having a property that's mid-flip, not a problem for them. They're going to pre-arrange to purchase it. So this was originally dismissed for failing to allege an antitrust injury. Originally, the court said, no, you haven't demonstrated where we have a conspiracy and what that conspiracy is. Is it one of our big four? You haven't shown that. But the Ninth Circuit reversed April of last year, and it reinstated the case. So that brings us up to 3 that the National Association is actively dealing with. And here's our number 4 is no longer active, but it's U.S. versus the National Association of Realtors. And so this is where the Department of Justice sues directly NAR. And it was filed in November of 2020. And the Department of Justice claimed that NAR was engaged in several antitrust behaviors. The suit was voluntarily dismissed when the Department of Justice and the National Association entered into a settlement agreement. So the Department of Justice says, you're involved in these behaviors. NAR says, how can we change our behavior so that you do not view it as antitrust? And this is the rules that were changed. Prohibit NAR affiliated MLSs from disclosing to prospective buyers the commission that the buyer broker will earn if the buyer purchases a home listed on the MLS. We're repealing that rule. Allow buyer brokers to misrepresent to buyers that a buyer broker services are free. Remember, buyer broker services are not free. They're paid. Okay. Enable buyer brokers to filter multiple listings that based on the level of buyer broker commissions offered. Now, they come to this agreement and the suit's dismissed. They say, okay, as long as you make these changes, then we're cool in the game. However, the Department of Justice withdrew from the agreement in September of 21. They said, we've changed our mind. We want to reinstate the litigation. We're not going to withdraw, and we're going to go forward with the case. But in January of 23, the National Association had a huge victory, and the court determined that a change in administration, going from the Trump administration to the Biden administration, did not allow the Department of Justice to withdraw the agreement and reinstate the agreement. Okay, so Randy Shaw says, the buyer's agent can negotiate with the buyer to receive payment above and beyond the declared commission amount. Absolutely. As shown in the MLS, I have brokers that successfully complete transactions with the buyer paying an additional amount above and beyond the designated commission account. Doesn't this nullify the argument that the buyer's broker has no ability to negotiate for commission? That's part of the argument. That's part of the response that we can say. We can say, okay, but then do we have a minimum in place? So you're saying we can negotiate to go above, but then do we have a minimum? And if we have a minimum, remember when we looked at conspiracy, and that was part of my price fixing issue, is I've got that minimum. So yeah, my buyer broker, they have the ability to negotiate, but that's above and beyond. Does that make sense when we look at kind of the parts of this complaint? The way that it's moving forward, you're absolutely right. And it's one of the arguments that I think we will see. And then here is my interesting case to follow. It's RealPage. Now, I don't know, I asked earlier how many of you were property managers, and I did not get a lot of, yeah, that's me. It's a property manager case. But the reason that I think we need to pay attention to it is because of the way that it links back with what we do. Okay, so RealPage is software, or it's a software company. And a lot of their software is used by property managers, and it's fascinating. So the way that RealPage works is I'm a property manager, and I'm like, I'm going to become part of the RealPage system. And so they have a side that will handle processing payments. They have boilerplate leases that I can use. They have all this great tools that I can use. That's great. And then on the other side of being a RealPage consumer, I have agreed I will provide you with information about my properties. And then I'm also going to provide you with the how much I get paid in rent a month for each property. And I'm not just going to say, oh, I have a 3-bedroom, it's pretty nice, and I get paid $1,500. No, I'm going to provide documentation proving that I have a lease for that amount, and that's what I'm receiving. So I've got the receipts. So I'm demonstrating this is the condition of my property. This is where my property is located. This is what my property currently rents for. And so when we look at RealPage, it accumulates all that data from the subscribers, including that the rents, what the rents charged are. Now, all of that pricing data is then put into an algorithm. And so the algorithm makes daily recommendation for pricing on rental properties. So I want you to think about kind of the comparison. So to something like a multiple list, if I'm looking at doing a broker's price opinion, or if I'm going to a listing agreement and I'm going to say, this is a good price to start, I'm looking at my comparables. What did comparable properties in the area sell for within the last certain amount of time, right? Now, RealPage is doing something very similar, or allowing users to do something very similar, right? Because I have folks who are saying, this is what I rent for, here's information about the property. Very similar, right, to what we have in the multiple list when it comes to this is what the property is, this is where the property is located, this is what the property sold for. Very similar when we have what it is, because the key to the multiple list is in places that don't have public disclosure. It provides the actual, not just what I advertised the property was going to be sold for, but it provides the deeds, the receipts. This is what it really did sell for. So RealPage does the same thing, okay? But it takes it a step further. It's not just here is the accurate information that we've guaranteed. It feeds it into an algorithm and it says, okay, based on all of these comparables around here, this is the price that we would recommend that it rent for. Okay. Then in November of 22, investigations were opened into the way RealPage operates. Now, the interesting thing that comes out of the RealPage case is most property managers historically have said, I need heads on beds. I want high percentage of occupancy. No ADD here. So high percentage of occupancy. So when we look at that, it would be like saying, I have 10 apartments and they are in phenomenal condition, and I rent them 100% occupancy for $100 a month. So I'm bringing in 10 times 100, $1,000 a month. Okay. RealPage comes in and they're saying occupancy is not necessarily the key. We don't need 100% occupancy. If we instead have 10 available units and we are renting 8 of those units at $125, then I've got, math, 800, then I'm still at my same income, but I've got 2 additional apartments that can rent later. So they're not pushing occupancy, they push higher. So if I stay at 80%, but then I have my 10 apartments and I go from, wait, no. If I have my 10 apartments and I have occupancy of 8, which would be 80%, and I go not 125, but I go to 150, then I have lower occupancy but higher income. And if I have everybody in this area is using RealPage and they're following the RealPage algorithm, then what issue do I have? Price fixing, potentially, right? And that is the claim, is that RealPage facilitated competitors sharing information about what their prices were and then manipulating their prices based on that real knowledge. Now think about it from a multiple list perspective when we look at brokers' price opinions. See what I'm saying, where the claims kind of overlap? So I really think that we need to pay attention to RealPage because it also takes into consideration when we're dealing with an algorithm or artificial intelligence or machine learning. So if I'm going to take data that I have gathered and I'm going to plug it into machine learning software or machine learning program or an artificial intelligence program to come up with, this is what I should set my rent at, this is what I should set my price of my property at, then we've got a real issue. And so RealPage kind of opened the door. And then we had great guidance from the head of the Federal Trade Commission at the time. And so she explained, when we look at anything, an algorithm or AI or machine learning, anything like that, replace the name of the program with a guy named Bob. And so if you have 20 property managers and they all give this information to a guy named Bob, how nice is my property? Where is it located? How big is my property? And what did I rent it for? And then the guy named Bob tells everyone what they should set their rents at based on that previous information. Do we have a potential antitrust violation? Because when RealPage was introduced, the response from so many was, it's an algorithm, and an algorithm can't have a problem. An algorithm cannot violate this law. But the response is very clear. If we replace algorithm, replace the name of the software program that we're using with a guy named Bob, it makes it much clearer when we have the potential that my technology solution to my problem is leading me astray. So RealPage is definitely a case that I think that we should follow. All right, any questions on antitrust before I move on to data security? Do I have any thoughts on how this will get settled? None that I would say and be recorded saying. These are tough, and it's one where we really need to watch, and it's one where we also have to see behaviors changed. So when we talk about behaviors being changed in antitrust, it means buyer's agent be able to explain, this is the service that I provide to you. Be able to demonstrate what value you bring to the table. When I first kind of looked at this whole buyer's agency thing, it made me think of Amazon versus Best Buy. Okay, so what do you go to Best Buy to do? Try stuff out, right? I go to Best Buy to physically look at the computer. Do I like it? How much does it really weigh? Does it seem functional to me? Is the keyboard weird? I want to try it out. Do I then buy it at Best Buy, or do I go back to my office and look it up and order it from Amazon or order it from an online retailer for cheaper? Yeah. So when it comes to buyer's agents, are you Best Buy, meaning all you do is have a key and you let them in and then they dump you and handle everything themselves? Or are you going to provide full services and be able to demonstrate, I do so much more than just open the door for you. I do this for you. I do that for you. This is what I'm going to do for you. Because we need to be able to demonstrate why buyer's agency exists, why buyer's agents are getting paid. And then we also need to start thinking, if the structure changes and if the buyer's agent were not to be paid from proceeds of the transaction, then how are we going to set those prices? And when I say set those prices, not set those prices as a community, I mean, how would you look at the services that you provide? And so this is one of those things, I mean, as an attorney, I'm billable hours, baby. And then when I left my firm and I went out on my own, I was like, oh, all of the reasons that I gave for what my billable hours were have changed now, because I don't come with a huge team of secretaries, and I don't come with a huge team of paralegals, and I don't have this enormous overhead anymore. Does the pricing structure continue to make sense? And so it's kind of that same analysis that folks are going to be faced with. It's going to be a major change. Right, data. It's 2 a.m. Do you know where your data is? How many of you remember the Equifax breach? I think we're about 4 years past it, but it impacted every American with a credit score and most of Canada. The Dropbox breach, when for 45 minutes, nobody had to have a password to get any document out of Dropbox. Do you remember when Facebook had a breach? Or the entire federal government when China breached, and if you were an employee of the federal government, all of your data was taken? Those are the breaches that we remember when it comes to data breaches. But the data breaches that we deal with on a regular basis, and the majority of data breaches in the United States, are small companies. Now, for me, the most telling data breach in US history was Ashley Madison. Now, how many of you remember the Ashley Madison breach? I will not make the mistake and ask if any of you were users of Ashley Madison. How many of you have no idea what Ashley Madison is or was? Right. I noticed that it's dudes who are like, I don't know. I have no idea. I have no idea what you're talking about. Okay. Ashley Madison was a dating website. But unlike a traditional dating website, to use Ashley Madison, you needed to already be married. So I'm married, but I want to date someone. So I'm going to go on Ashley Madison, and Ashley Madison is a group of other individuals who are married, but they also are looking for a boyfriend or girlfriend, someone to date. Crystal Rogers, what? Exactly. So Ashley Madison, when this breach happened, and the reason that it was so interesting to me is all of you who are saying, I don't remember this, I have no idea what you're talking about. Yet in the United States, there were only 3 zip codes that did not have an Ashley Madison account. Nikolai, Alaska, who has a population of 94, where winter temperatures dip to 60 degrees below zero. Seen a trend here. Perryville, Alaska, population of 113. Only 10 households have an internet connection, and it's dial-up. And then Polvidera, New Mexico, which is a population of 269 miles. For some people, this is your dream residence. It is 4 square miles in the middle of the desert where there is no internet, there is no cell service, you are completely off the grid. There are no water, there is no electricity, you are nowhere. So no Ashley Madison accounts associated with that zip code either. That was it. Everywhere else, every other zip code in America had an Ashley Madison account associated with it. Now, the interesting thing about Ashley Madison, to me at any rate, is the first class action lawsuit as a result of this breach. So we've got hundreds of thousands of names flooded out there of people who had used Ashley Madison and all of their account information. And so the 2 biggest class action lawsuits as a result, the very first one was if you had an Ashley Madison account, you could pay Ashley Madison $25. And Ashley Madison said, if you pay me $25, I will remove anything on my site that indicates you ever had an account. We will scrub you from the system. Nobody will ever know. It will be like you were never here. So Ashley Madison received those $25, and then it actually put everybody that paid to have their account scrubbed into a different category. And so not only when it was released when the breach happened and it was released, not only did your significant other know you had an Ashley Madison account, the entire world then knew that you paid $25 to have that information scrubbed. So the first class action lawsuit are those folks, the ones who are suing Ashley Madison, a website that exists to just help you cheat. They are suing that website for cheating them. Beautiful, beautiful, beautiful America. Second lawsuit, class action lawsuit that came from that was when it was released, they discovered that the majority of female participants, and so these are memberships that claim to be a female living in a certain area, were not those females living in the certain area. They were men that were hired by Ashley Madison. Again, You're suing you're suing a website that exists to help you lie to people for lying to you. Beautiful, beautiful, amazing. But when we look at kind of the takeaway when it comes to Ashley Madison, is what types of breaches really impact people and how do the breaches happen? And so when we look at like Equifax, that's a financial breach. They wanted financial information. When we look at the federal government breach, that was a state action. That was a state, China, attacking our nation. And then when we look at Ashley Madison, the goal was to embarrass. And so we have different reasons that breaches happen. Now, when we look at the breaches that happen in real estate, those are financial based. And so when we look at the financial breaches and kind of everything that drives that, the majority of data breaches, over 70% of them, are in companies that have fewer than 100 employees. The majority of breaches actually happen in companies even smaller than 100. Now, of those breaches in 2022, 1 billion emails were exposed. 20% of internet users, so folks who use email, 20% of them had at least one email that was made public due to a breach. Half of all American internet users have at least one account breached in 2021. The most common cyber threat facing businesses and individuals is phishing. Now, phishing at least is a cheap breach to happen. On the bright side, phishing had the lowest loss to victims at an average of $136 per record that was phished. Phishing attacks increased by 61% in 2022, and they continue to grow in 2023. So the human element is the root cause of 82% of data breaches, something that I did that resulted in the breach happening. And so most of us think data breach. I always think like somebody in their mom's basement wearing a hoodie, typing in the dark. Because if you go on to like stock images and you search hacker or data breach, that's what you get. That is not the reason for the majority of breaches. The majority of breaches are I did something, and as a result, my data became easy to access. So what does a real estate data breach look like? Because it's not a guy in his mom's basement. So I taught a class on side hustle. So this would be like Airbnb, VRBO, that kind of stuff, your side hustle housing. And an agent came up to me at break and she was like, Trista, I have the best side hustle. And I'm like, oh no. Because as soon as somebody separates themselves from the group and comes up to me to talk side hustle, they usually want to sell me like LuLaRoe leggings or Rodan and Fields face cream. So they're either saying you wear too much black and need some bright, colorful, tight leggings, or you are a wrinkled mess and need some anti-aging cream. But that's not what she's trying to sell me. She comes up and she's like, I have the best side hustle ever. I'm a team leader. And I'm like, what kind of team? Real estate team. This is a real estate class, Trista. I was like, oh, okay. So you're a team leader. Are you paid extra to be a team leader? She's like, no. My side hustle. So I have a team and it's a pretty big team. We have 20 licensed agents in my team. I'm like, that's a pretty big team. She's like, our claim to fame and the way that we advertise is for the last like 3 years, we have had 365 closings. So all of our ads are, we sell a house a day. I'm like, okay, that's fascinating. That's a lot of closings. She's like, so I have this worksheet that my agents fill out, the members of my team. And I'm a huge fan of worksheets. So I'm like, oh, what's your worksheet? We gather information about our clients. So if we're representing a buyer, it's going to have my buyer's name, the house that they purchased address. It's going to have their email address. It's going to have anything that we gather about them during the transaction. So like birthdays, wedding anniversaries, sports their kids play, things that they're interested in. And so my mind immediately goes, book of business. All right, you're building your sphere of influence. This is important stuff. She's like, so we fill out this worksheet on our client, and then we gather as much information we can about the other side in the transaction. So if we're representing the seller, of the property, we're going to try to find like where did they move to, or if we're representing this, I'm sorry, if we're representing the seller, we're going to get the buyer's name from closing documents, and we're going to get the buyer's new address, and we're going to get whatever it is that we can about this buyer. Like, oh, okay. And then at the end of the month, we compile all of the worksheets and then we sell them to our preferred service providers. I'm like, you do what? She's like, I have these preferred service providers. It's a lawn care company, an independent internet provider, a handyman company, a painting company, and like there were 2 or 3 others. And at the end of every month, we compile these worksheets and we sell them. What do y'all think? Is that okay? Is that a side hustle? And I was like, whoa, that's a lot. That is a lot for me to take in. And so my attorney brain is like, what does your broker think about that? What's your broker say? She's like, oh, I wouldn't tell my broker. She would want a cut. Your broker doesn't know that you are gathering information about her clients, because whose clients are they? The brokerages, the brokers. So you're taking information about the broker's clients and you're selling it. She's like, yeah, I make bank. All right. First off, yikes. Yikes. That's a huge yikes, because we look at this from the perspective of, have you provided your clients with an explanation that during the course of our relationship, I will gather information about you, and that information I'm required to keep for a certain number of years under state law, and then this is what I will do with the data. Now, as a consumer, having gone through enough data breaches, if I'm going to provide you with information about me that's personally identifiable, I want to know what you're doing, and I expect you to tell me if you're going to sell my data, because every website I go on, they tell me if they're going to sell my data or not. Everywhere that I go, they're going to tell me if they're going to sell my data or not. I bought a new couch. The furniture store told me, we're going to gather information about you. We're not going to sell it, but we're going to send you brochures. Okay, I need to know. And your clients have that expectation. So are you providing your clients with information about the personally identifiable information you're going to gather? And then, do you have a system in place within the brokerage where you have rules that members of the brokerage follow? If you're a team leader, are there rules that your team follows? As an agent, are you getting guidance from your broker and brokerage on how I store the data that I have from my clients, that personally identifiable information? And then I want us to look at that independent contractor agreement. What does that independent contractor agreement, or the policy manual that's followed by agents in a brokerage, what does it say about client data? What does it say? And then what does it say about an agent keeping an independent copy of files? Okay. Now, the reason that I harp on that, what does your independent contractor agreement say about files being stored by an agent, is, where's my case study? Oh, I thought I had a case study. So if I am with a broker and my broker says, we're going paperless, we're going paper light, everything is going to go into our new management software program, and then if we get audited, then it's going to be a digital audit, and we're going to follow the rules that the board, our licensing board, has created. And okay, everything's going paperless, everything's going paper light. Can I make a copy of everything on my thumb drive as an agent? And then if I do make that copy and I have a falling out with my broker and I leave my broker and go to another brokerage, who is responsible for that information? Who would be held liable for a breach If I lose my thumb drive, where's it going to go? So who regulates data storage, data breaches? We do not have a federal law that I can point to and say, this covers it all. This gives you guidance. Instead, we have 48 different state laws. We do have the Federal Trade Commission Act, and the Federal Trade Commission looks at false or misleading claims. So if I tell my client, I gather your information, I keep it for 3 years, the only people that will see it are the auditor when I'm audited and members of my brokerage, but then I turn around and sell it. That's a deceptive trade practice. It's misleading. I told you I was going to keep it safe and I didn't. Those are the types of things that the Federal Trade Commission looks at. They also look at a failure to employ reasonable security measures that cause or is likely to cause substantial consumer harm. And they've said that is a violation of the Federal Trade Commission Act. And so all of our states, all 50, have a miniature version of the FTC Act. And so it would be a violation of that mini FTC Act as well. So where do we begin? We conduct a data audit, find out what it is you've got. Where are you keeping it? Why are you keeping it? How are you keeping it? Who has access? And then when are you getting rid of it? So as an agent, I want you to think about your client file. What's in there? Do you have their name? Yeah. Do you have their physical address? Okay, if you're representing a seller and you don't have the address of the house you're selling, you're doing it wrong. So I've got their name, I've got their physical address. Do I have their email address, even if it's just in my phone? What about their social media handles? Am I going to have those written down? How many of you took that safety class that said you should get a photocopy of their driver's license? So you've got a photocopy of their driver's license. How many of you get their birthdays so you can send them birthday cards? How many of you, even though you have told them repeatedly, I do not need to be included in the email chain with your mortgage broker, are still getting CC'd on everything with their mortgage broker? So you end up with a copy of the mortgage application in your inbox, even though you didn't want it. Look at all of the things that you have about that client. Personally identifiable information is going to be any of that that I can't just publicly get off of a public record. So it's possible that the client's name and their address would be available on a public record, depending on the privacy law that my state has on if that's public or not. Brokers, what do you have? Do you have your independent contractor agreement with your client, your incorporation paperwork, tax information so that you can pay your agents? How many of you have employment applications that you keep on hand because you also hire employees, not just independent contractors? Birth dates of those, and then passwords that your employees created to programs that they use in their employment. Meaning on my computer, am I using a password storage program that is keeping the passwords that are associated with the email that my agent is putting in? Because all that's going to fall within that PII. Then ask yourself, why am I keeping it? 3 acceptable reasons. State regulation requires me to. My accountant told me to. My attorney told me to. Unacceptable reason. At some point, the market is going to slow down and I'm going to go through those files and I'm going to dig out nuggets of information that are going to help me build my sphere of influence. Also unacceptable is we just keep everything always. Not okay. We only keep that record if we absolutely have to have it, because every additional record that I'm keeping, every record that I keep beyond the time that my attorney, accountant, or the law told me to, that's an additional record that I'm responsible for and I'd be liable for if we had a breach. So here's your Oregon law, and you are on the hook for 3 years for continuing education courses, and then let's see, 6 years for trust account authorizations, real estate transactions, rental real estate, all other records, the date the record was created or received. So you're 6 years basically. That's pretty good. What happens after 6 years? What do you do with it? But during that 6 years, I want you to look at, where am I storing the data? So this is, do I have a physical filing cabinet? Does it go in a digital filing system? Does it go into the cloud? And I don't know what the cloud is necessarily, but Steve Jobs is up there keeping an eye on it. Where do you fall within where am I keeping it? And then how do I secure the data? So am I locking it? Am I encrypting my data if it goes into the cloud or if it goes down to my private server? How is it that I am securing my data? And then how many of you are thinking, I have absolutely no idea. I don't do anything. The email comes in. I put the file where I'm told to put the file. I don't know the part of data security, because the part is where we need to be concerned. So encryption is a digital lock. And so I do actually know what the cloud is. It's a whole, if I have spare space, I can rent it out, I can meter it out. And that's the way the cloud was invented. It was actually by tax companies, tax preparers that had huge amounts of storage available they didn't use most of the time. So they rented it out in a metered system. So if I'm putting something into the cloud, or if I'm putting it on a thumb drive, or if I'm putting it into a server, or if I have emails that I am saving, all of those types of things, I want to make sure I'm encrypting them. And so if I encrypt it, it just means I'm using a program, and I just went onto PCMag and took a screenshot of their best encryption recommendations for this year. And I'm going to run it. So let's say if I'm using CryptoForge, okay, I'm going to use my CryptoForge, and it means what I see makes complete sense. But then I turn the CryptoForge, or I turn my CryptoForge on, and I store it. Anybody who accesses that doesn't have the encryption key, they just see gibberish. Nothing makes sense. They can't read that. They can't gather the personally identifiable information off of that unless they have the encryption key, and I'm the one that has the encryption key. If I'm emailing my client back and forth, and those emails are going to include personally identifiable information, I want to encrypt those emails as well. If we are program to program, so if I'm like Outlook to Outlook, AOL to AOL, Gmail to Gmail, the majority of those encrypt if it's within the same program. But if I want to make sure it's going to be encrypted, then I can use an email encryption program as well. And I can also use that email encryption program not only for when it is in motion, but it will also allow me to encrypt it when I have it in storage. Which means if somebody were to be able to log onto my computer, or if somebody stole my phone, they wouldn't be able to read those emails because they were encrypted, and they would need the password to turn the key to unencrypt. Then we look at who has access to your files, both online and in real life. So for 6 years, I was association counsel, and I was the government affairs director for an association. And so on most Tuesdays, I would go to or Mondays sometimes, I would go to the meeting of the brokerage, so like the Monday morning meeting. And I would go to either update them on some litigation that had happened, or I would go to spread the word of RPAC. And so I walk in the front door and I'm like, hey, I'm here for the meeting. I'm from the board. And whoever's at the desk would usually just wave me back and say, go on back, you're fine. And then as I'm walking down the hallway, I would see folks that are in the office. I'd be like, hey, what's good? What's good? Now, I don't know names. I'm not good at remembering names, but y'all alleviate my fear of not knowing someone's name because you wear name tags. So I could just look at your name tag and be like, hey, Grace, I'm here for the meeting. I forgot to make photocopies. Can you point me in the direction of the photocopier? Now, I became an attorney because I don't like people. Most realtors, you like people for some reason. You're people, and you like helping people. So if I'm like, I forgot to do this, can you help me? What is that realtor going to do? They're going to do copiers over there, help yourself. Now, what's next to the copier? Frequently, it would be the filing cabinet. So you have left me alone with your physical filing cabinet that has all this personally identifiable information in it. And even if you haven't left me with the filing cabinet, I've got your printer. Now, any of our newer printers aren't just printers. They're printers, they're copiers, they're fax machines, and they're also computers. and they have memories. And so if you've left me alone with that copier, I have the ability of looking at what has this machine been used to create over the last however long this memory lasts. And I can pull that memory and take it with me. So you've given me access to all of that information. So you need to look at in real life who has access, but I also want you to look at who has access online. And when we talk about online access, this is where we're looking at who is it that can go in and get on my computer and look at whatever contracts I'm writing, whatever emails I'm writing, what information am I gathering. And so this is going to be if I have a personal assistant. So I have a personal assistant. She's amazing. Her name is Anna. She is 18. I gave birth to her. She is leaving for college in the fall. And I guarantee you, when she leaves, she will either set my office on fire or change all my passwords just to be her. Now, in this case that this screenshot is from, we have an employee for a for-profit online college. And knowing that he was on his way out because he got fired, he took his last few minutes in the office, goes online and changes the password to all of the email accounts for the students. So they can't access their emails, they can't access their course materials. He does say, however, for 200 grand, I will give you the new password. Now, if Anna is the only one that can change passwords, or if Anna has the ability to change passwords and I can't figure out what they've changed to, then I've given her too much power, because I need to be the one that controls my files. I need to be the one who controls that information and how it's saved, because they're my files. And so when we look at the brokerage setup, then we're going to look to the broker first and say, what are your rules on how I'm saving this? And then absent those rules, we're going to look at the agent saying, I need to limit who can get on my computer. I need to limit who has access to the places that I'm storing these. If they don't need access, or if they don't need passwords to do their jobs, then they don't need to have that access. So I have my files that are associated with my law practice. Not all of those Anna needs access to. Anna has a limited amount of, responsibilities. And so her computer access is limited to what she has to have when it comes to those responsibilities. So she doesn't have the password necessary to get in and view my PII, the information that I don't need her to have. Then we look at best practices. And so when we look at in real life security, lock your static data, limit access to your data, and then also consider your computer placement. So when I talk about considering your computer placement, I think we have all probably worked from our, mobile office, which is usually like a Starbucks, unless you're in commercial real estate, and then it's Panera. I have no idea why that distinction is made. Or if you're in a place that has a lot of local coffee shops that are locally owned, that's where you're going. So if I'm sitting at my coffee shop, and it's my favorite coffee shop, and I'm just getting caught up on contracts, or I'm getting caught up on doing some work, and I look behind me and someone can see my screen, I'm giving them access to everything that I am entering, including passwords, any type of information that they can gather from looking over my shoulder. If I hear my name called and I'm going to go up and get my mocha, they never get my name right either. I get Trisha and Krista, and every once in a while a Teresa. So I go up to get my coffee and I leave my computer alone. I'm giving access to anyone around for the amount of time that I'm gone. I flew to Wyoming last week, and this very nice gentleman in the airport was like, I got to use the restroom. Will you watch my computer? And I'm like, dude, it's a PC. You don't have to worry. It's a Dell. Nobody's going to steal it. But he's gone for like a good 10 minutes, and he's just entrusted me with his computer. Anything that was on that, I would have been able to have access to during that time. We need to consider how we're using that. And then we're going to implement passwords. And passwords seem so basic, but they're so important, their first line. And so especially when you look at the fact that 17% of people using passwords are using the password 123456. Not okay. The point of passwords is to make it complicated for someone who doesn't know you to log on, and then to make it complicated as well for someone who does know you to log on. So if my password for everything is Anna, the name of my daughter, plus her birthday, and that's the password that I use for everything, anyone who knows me is going to know that that is my password, or they're going to know the likelihood that it's going to be. Stop putting passwords on sticky notes and then leaving those sticky notes around. No need to have a password journal. We want to limit the number of places that we make our password accessible. If you can't remember your passwords anymore, and I'm definitely in this boat, I went on to PC Mag in last August and I looked at what are their recommendations for a password manager. And one of the things that I always look at when it comes to password manager, because when we look at a password manager, it's not a question of if they have been breached, it is when they will be breached. I always want to look at, when it comes to that password manager, how much control do I have? And then what am I including in my password manager? So I'm not going to include like my banking information. I'm not going to include a lot of my business information in my password manager. I'm going to keep those separate from that password manager that might be able for a breach. And then I'm also going to make sure that I am updating my passwords, that I'm not using the same password forever. So I have a calendar system in place. I keep my phone organized and I update my apps based on a reminder that I set for myself where it's like, oh, you're going to update your travel apps today. So I get new passwords for those through my password keeper. And then apply your updates, your patches. Now, when updates, when we look at these updates, when we look at the patches, a lot of folks are like, oh, it changes the system. It's annoying. It's this thing you have to do. The reason that the patch exists is a weakness in the system was found. Frequently, it's a weakness in the system that allowed for someone to gather information through that or to breach the system. So they apply the update. And if you don't apply the update, then it doesn't apply that new security. So like the biggest virus kind of in the history is the Conficker virus, and it hit millions of computers in the mid-aughts. The interesting thing about the Conficker virus is if you had updated your computer in like 2008, you couldn't get the Conficker virus, but it took down millions of computers in 2009 for people who just hadn't updated their computer in a year. So we need to make sure that we're applying those updates, like the update that was for Zoom in early 2020. Some of those early users of Zoom, when COVID first hit, you probably remember that we had Zoom bombing and that we had a lot of weaknesses discovered in the system because Zoom did not do end-to-end encryption as well as a few other things. So they applied that patch in early 2020. And if you had not applied the patch, then those problems still existed. And so Zoom had to really crack down and say, you've got to apply the patch. So that was our lesson learned in 2020. And then just a quick little note on some of the technology that we started using since then. So when we look at Zoom, we had the patch that had to be applied. But I also want you to look at things like Google Duo, FaceTime, WebEx, GoToMeeting, WhatsApp, the tools that you are using to communicate with your clients now that maybe historically you were not using to communicate with your clients. I want you to take a step back and see, is what I am putting in this going to be open for other people to see, or is it going to be encrypted end to end? Meaning I see your face on the screen here, you see my face on the screen there, but while it's in motion, while the connection is happening, it's encrypted so other people cannot see the packets of information that we're passing back and forth. So if I'm using FaceTime to regularly go over contracts with my clients, I want to make sure that it's end-to-end encrypted because we're sharing personally identifiable information. Use your administrative privileges and then use that preventative software. So some of you probably grew up with all of those Apple ads saying, you know, apples don't get sick. And if there's anything we learned from Sex and the City, it's that apples do get sick. And so when we look at using preventative software, I just went to PC Mag again and pulled up their recommendations for that preventative software. And then the last thing that I want you to do before I free you, because I promised you I would get you out because we took such a short break, is I want you to look at the Internet of Things in your home. What devices in your home, what devices in your office are connected to the internet? Because every time you connect something else to your internet, then you are allowing that to access the same internet that you are accessing to save your files in the cloud, to transfer files to a server, to transfer files back and forth with a client. So I want you to see, what am I connecting to the internet, and am I updating those regularly? So things like we have a Nest. That is what we use to set our temperature in our house. Then we've also got the Nest cameras, and we also have Ring the Doorbell for our camera. And then we have the LG suite of appliances that are all connected to an app that I can control them with the app that goes through the internet. All of those devices. Oh, and don't let me forget R2D Floor, our Roomba. All of those that are connected to the internet, then I'm opening another door to my internet connection. So I want to make sure I'm regularly updating those devices, and I'm employing any security that can be associated with that device as well, so that nobody has the ability to come in and control things in my office or in my home or access data that way. All right, are there any questions for me? Because we have hit 150 minutes of talking. Here we go. Thank you, Jen. Thanks, Tiffany. Oh, and I will, I sent a PDF to Erica. And so I think we're going to be able, through the Oregon Realtors, to get out a PDF of my slide deck if you're interested.
That's awesome. And for all of our members that were joining us today, please share with your friends of how amazing this was. And Trista, your information was incredible. So thank you so much for all of the info that you provided. I know that you saw me coming in and chatting quite a bit because I had my mind open to a lot of things.
And I want to answer the question about Alexis. Okay. I have to admit, I have Alexis issues, and I have Alexis issues in real estate, because it makes me so nervous if I'm going to go into a property and there is Alexis, because remember, Alexis is always listening, and Alexis could be recording. And when it comes to Alexis, then I'm also very concerned about Alexis when I've got it connected to other entities. So if I can order groceries, or if I can order something off of Amazon through my Alexis, that makes me very nervous, because who else has access to my Alexis when it's part of my Internet of Things? So my sister has Alexis, and we prank each other on the regular. And we discovered over Christmas that you can actually add things to her Amazon account and order them and have them delivered to her just through Alexis. So we ordered some fun stuff for her, all of which was highly inappropriate to talk about in this class, but it was delivered to her, and she then had to figure out if she wanted to return it or not. So when it comes to your Alexis, yes, you can change those passwords, and you want to make sure that you are doing that. You also want to make sure you're limiting who has access to that. And thank you, Jen, for saying my teeth are nice, because they're really not. This throws me off. All right.
Awesome. Well, thank you. And yeah, like I said, if for those of you that are here today, just share with your real estate sphere of how amazing this class was. I did see that we posted we won't be sharing the recording with the attendees, which of course we know that. And so I want to make sure that you're sharing the great information that you learned today. So thanks again for joining us today for the Don't Get Burned Cannabis Litigations and Data Security with our wonderful speaker, Trista. Which, by the way, Trista, you really made this an entertaining and interesting course. I'm sure we've all taken similar courses where it's a little more dry. So thank you for making it and holding our attention.
Thank
really
you.
appreciate
Thank you.
Yes. And as a reminder to those attendees, your CE certificates will be emailed from Rogue Valley Association of Realtors within a week. And then a short 3-minute survey will be emailed to all attendees here shortly. And we would really appreciate your prompt and honest feedback. Thank you all so much for joining us today. And we hope to see you in the near future in another education event. Thank you all. Have a great day.